Does reservation serve the intended purpose? Are India's socially backward classes gaining from reservation? These questions often result in emotional responses, but these issues also reach the courts. Today, the Bombay High Court has upheld the Maharashtra government's decision to provide reservation to the Maratha community under the social and economically backward classes. So why is this an important matter? One, because of the scale. The state government wants to give 16% reservation to the Maratha community. The court found the 16% reservation unreasonable. The court's decision has sound rationale, we may add. After all, Maharashtra's Backward Commission only recommended 12% reservation for Marathas in employment and 13% in education. The court said that the state has all the rights to give reservation to backward classes and that the state can exceed the 50% ceiling for reservation, but it did not agree to the 16% figure. Earlier, the state government had notified on this issue on November 30th, 2018. Now, that is legally valid. The High Court's order, in fact, ruffled a few feathers, but political parties seem to be happy. According to the Mandal Commission, Marathas are not a backward class. They are, in fact, categorized as a forward class. Other backward class commissions headed by S.N. Khatri, R.M. Bapat, and even the National Backward Class Commission have also concluded that Marathas are not backward class. The question is, has the High Court overlooked the conclusions of all these commissions? Critics say that the Maratha reservation is exclusive in nature, but the state government says the reservation is needed to promote Marathas in service and education. This issue has already had an impact on the medical admissions in the state. There are 156 seats reserved for MS and MD courses for Marathas in Maharashtra's medical colleges. Had the government not brought this special reservation, then these seats would have gone to the open category. Now, what does the law say? Article 15 and 16 of the Constitution of India, as well as the Apex Court judgment in the Indra Sawhney case, bestows the right to state governments to grant reservation. So the state government has not broken any law technically, or has it? A 1992 Supreme Court order caps reservation in government jobs and education to 50%. But states have used a loophole in this law to extend the cap. At the moment, there are 4 states which have reservation above 50%. These states pass the reservation under the 9th schedule. Now, laws under the 9th schedule are beyond the purview of judicial review, even if they violate fundamental rights. Tamil Nadu, for instance, has 69% reservation. Maharashtra has 52%. Telangana and Haryana also exceed the 50% threshold. Recently, Rajasthan and Gujarat saw such protests by communities to be granted reservation. India's political parties need to understand this matter. It's not about winning elections only by appeasing members of a community. Irrational reservation is going to lead to social discontent. Even Dr. Ambedkar did not envision reservation for eternity. With reservation, the policymakers are making a ticking time bomb. At some point in time, the debate over natural justice versus social justice will become too hard to handle. Take the example of Maratha reservation. This whole 16% reservation pitch was made by the Congress and the NCP ahead of the 2014 Assembly election. Now, the BJP-Shiv Sena combined has taken the mantle of social justice upon itself ahead of another Assembly election that the state is going for later this year. It's a clear case of politics taking precedence over public policy and planning, a sad state of affairs.